Welcome to our vidcast series, Decoding Appeals. This is episode 3, where we're going to be talking about the life cycle of a Supreme Court of the United States appeal. My name is Michael Steinberg. I'm one of the members of the Appellate practice group here at Seyfarth Shaw, and I am delighted to be joined by one of the other members of our Appellate practice group here today, Chris Robertson, who's a partner in our Boston office, where I also sit, and I'm really looking forward to this conversation. Thanks for joining us, Chris.
Afternoon, everybody.
So we're all used to thinking about the Supreme Court as this, Supreme Court, this ultimate court of last resort for the entire nation. And we usually think about it because it issues decisions that are really important and that affect our clients and, businesses and people throughout the United States. But sometimes we actually end up practicing in the Supreme Court on appeal. And so that's what we're going to talk about today. But before we jump into the nitty-gritty of Supreme Court appellate practice, Chris, I know for a fact that you are an avid SCOTUS watcher. I'm an avid SCOTUS watcher. Probably a lot of the people tuning in are as well. Are there any cases coming up for the new term that just began that you're keeping an eye on?
Yeah, I mean, we always look because, as folks know, what happens is and we'll talk about this a little bit later, where the Supreme Court gets thousands of petitions for certiorari to look at cases they're going to take up, and they take only a small fraction of them. And they take them, and then what they do is they'll decide them during what's called their term. So we have the ability, before a case is even briefed or argued, to understand what cases they've taken up and what they're going to look at. And that's all ahead of the arguments and ahead of any decisions. And so in scanning those, you sort of figure out what your practice concerns are. I'm head of our whistleblower and securities litigation practice. So for me, obviously, the cases that matter to me may be very different than cases that matter to a lawyer that practices, as for you, Michael, in labor and employment, or
Right.
someone who's in antitrust. But for me, the case that really I'm looking forward to hearing and seeing how they decide is the Facebook versus Amalgamated Bank case, which involves risk disclosures and securities filings, and whether disclosing a risk where there's a known event that has occurred can be fraudulent to shareholders, or if there's that risk disclosure that is essentially cleansing of the filing. So that for me in a securities space is something I'm looking forward to seeing how it turns out. How about you, Mike?
So as you mentioned, I'm in our labor and employment group here at Seyfarth. And so one of the cases that the Supreme Court actually just granted cert in, which I think a lot of us will be watching, is the Ames versus Ohio Department of Youth Services case. This was a Title VII case in which a state employee who's heterosexual claimed that she was demoted and ultimately, passed up for a promotion as well because of her sexual orientation. And so the question for the Supreme Court will be, what standard applies to evaluating discrimination claims brought by members of the so-called majority group? And so this is on appeal from the Sixth Circuit. We'll be watching it both because of how it impacts Title VII law and those kinds of claims all over the place, but also companies' DE&I initiatives for sure are going to be, potentially seeing repercussions from what the Supreme Court does there. So I'm looking forward to hearing the arguments and seeing what the Supreme Court does there. And looks like we've got an interesting securities litigation case that you're going to be keeping your eye on as well.
Indeed.
All right. So jumping in now to practice at the Supreme Court, unlike any other appellate court in the United States, the biggest battle or the biggest hurdle to overcome at the outset for the Supreme Court is actually just getting the court to take up your appeal if you're the party appealing. So what are some of your thoughts about, important practice pointers and items to keep in mind in terms of filing what's called a petition for certiorari, and also opposing one of those if you're on the other side and you don't want the Supreme Court to take up the case.
So some of this is in the rules, but some of this is just practice pointers for those that have, brought cases through the Supreme Court or sought to get a case reviewed. The rule itself is Rule 10, and Rule 10 has three basically defining characteristics of a case that ostensibly would make it worthy of Supreme Court review. Now, understand the Supreme Court has full discretion. So even if a case represents, for example, a split among the circuits, they may still not take the case. Even if a case represents a state court, highest court decision of a state Supreme Court that in many people's eyes may run afoul of the Constitution or run afoul of federal law, the Supreme Court may not take that case either. The kinds of cases they certainly will not take are cases, and they say this right in the rule, is just asserting that there's like an error in the factual findings or a misapplication of the law, but not a misinterpretation of the law. So that's not going to get you anywhere. So what you have to do is think about, what is it about my case? What is it about the legal implications of my case that create a federal issue, a federal law issue, including the Constitution, which is a federal law, that will create either a differing opinions among different circuits, differing opinions among the state courts and the federal courts, or some state or federal decision that runs afoul of constitutional provisions. And then it's key in framing your case that way to make sure that's the question presented when you file your cert petition, so that the court immediately understands, well, why is this something that warrants our review?
So it sounds like that question presented is a feature of a petition for certiorari. How important is it to frame that in a compelling way? And I know that's somewhat of a leading question, but could you just speak to that a little bit?
Indeed. Yeah, I think it's one of the more important things you can do in your petition. These petitions for certiorari, they get, like I say, thousands of them. Many of them are from the criminal side. Many of them are habeas petitions from prisoners. They don't have to pay their fees, so they can file those without having to pay a fee. So they get a lot of those, but there's still several thousand cert petitions that don't fall in that bucket, and the court will take up roughly, a single-digit percentage of those in any term. So you have to distinguish your case, the issues, the legal issues, from all these other petitions that have been filed. And how do you do that? A critical piece is how you pose the question. What is it about what happened in your case legally? Again, not factually, but legally. What was the legal application in your case that creates this conflict, that creates this necessity of further review? Because ultimately, your only right of an appeal is to the federal circuit court. You have no right to go to the Supreme Court. So the Supreme Court needs to see something in your case that creates confusion among the circuits, creates confusion in the courts that they need to clarify one way or the other. And how do you put that? You put that right up front in your question presented.
Now, sometimes, parties get to the Supreme Court by posing a question presented, and then the issues may shift during the course of litigation. What, in terms of thinking about where the Supreme Court's going to end up if they do take your case, what should practitioners be thinking about when they're framing the issues that they choose to raise in the cert petition?
Yeah, I mean, the way the cert petition is framed and the way it's then granted, assuming it's granted and you move forward, that is going to define the issues in the case. So, changing course in the middle of that process tends not to be successful because the court wants you to focus on what it is that you and, the parties have stated is the issue in the case. Obviously, when you file a cert petition, it's not mandatory, to file an opposition, but most appellees will do that. You're the appellant in filing a cert petition. The appellee will oppose it, and what they'll try to do is reframe the issue or say the way you've presented the question is incorrect, and the real way the question should be presented is something that would not warrant Supreme Court review. This is just a disagreement with what happened in the court below factually or legally, but it's not some significant question or dispute or inconsistency in the law. So if your cert petition is granted over that objection, you need to be extremely careful not to then later in the proceeding change the issue to sort of buy into what your opponent might have said, and take off the table a constitutional issue or a Supreme Court worthy issue that that existed previously, but now you've changed your briefing so it doesn't. Because the Supreme Court is looking at, what is it you need us to decide that we can then, give guidance to all the other courts in the country about how they need to handle these issues. And if it's just a local issue, it doesn't have that broader scope, then typically they're not going to address it.
So one of the issues that we talk about a lot in appellate practice is making sure that the appeal is filed in a timely manner. In the Supreme Court, the document that usually starts the appeal is the filing of the cert petition, as you were just talking about. Do you have any tips or sort of pointers that may be helpful for people thinking about ensuring that cert petition is timely, given all the different ways that a case can end up getting to the cert stage?
Yeah, I mean, the key is always thinking about the issues in the courts below that are the appellate issue. Most cert petitions are going to be filed after a final judgment. That could be a final judgment on a motion to dismiss or summary judgment or after trial. And you have 90 days to file your cert petition. But there are times, it's rare, it's extremely rare, but it does happen, where there can be interlocutory, middle of the case review. For example, let's say an injunction is granted. Most famously, the recent case that came out of Texas with their abortion ban, that warranted, essentially interlocutory review. And the Supreme Court not only took that in the middle of the case, actually very earliest stage of the case, they actually removed that from the Fifth Circuit and took it directly. So they can do that. But those are those very unique cases where you would have something like in Texas, where you have a statute that the minute it's enacted and potentially could have a chilling effect on the conduct of actors within the state, needed that sort of immediate review. We go back to the Nixon papers, or some of the Watergate cases, or more recently some of what's happening with Trump and the immunity decision. So those are all cases where the issue is so critical into how the case is going to move forward that they need a ruling at that level much earlier in the case than most. But the vast majority of cases are going to be after a judgment is issued, one way or the other, win or lose. And then from there, you have 90 days in order to file your cert petition.
And sometimes, at least in my experience, an especially persistent opposing party may, in an intermediate court of appeals, may move for rehearing, or some sort of relief, either panel rehearing or in-bank rehearing. How does that affect the 90 days, if at all? Does that give you even more time to file your cert petition?
It depends.
That's always the answer, isn't it?
Yeah, this is why looking at the rules, the local rules, the rules of the Supreme Court are so critical. You would not want to be on the wrong side of that issue. You would not want to, because you think that you filed some motion in the court, or a motion for reconsideration, or a motion for rehearing, or on bank, that would somehow stop the clock. In many cases, it doesn't. So, but what you can do, and most justices will grant this, is you can seek, even though the 90 days is jurisdictional. So the 90 days is jurisdictional. If you miss it, you miss it. You're out. But the sitting judge in the circuit you're in, each of the judges is assigned to circuit, can grant up to 60 days extension. So, one good practice pointer is if you feel like there's still proceedings going on in the lower court that you need to address, and you're concerned that, you might be running up against your 90 days, you can seek that 60 days and explain in a short filing why you need that 60 days based on ongoing proceedings in the lower court. And in the vast majority of circumstances, it'll be granted. And we've even seen that in some of the dockets that we looked at this term, where the cert petitions were filed, 120 days out because they got that extension.
So that really seems to underscore the importance of bringing to bear appellate practitioners really well before you actually need to be, preparing your cert petition, ensuring that issues of timeliness down the road are addressed by folks who are familiar with Supreme Court practice and able to ensure that there is no issue perfecting the appeal.
Correct. And I think it's also important for that to understand sort of how the cert petition should be put together. There's a very specific structure to it, with the questions presented, as we talked about, with the issues of law, with the defining the lower court proceedings, really framing the issue that you're asking the court to take up. And, some of this is by rule. There are very specific rules about, what the cover page has to look like and what the brief has to look like. But more importantly, it's really that sort of thinking process about, sizing up the court. What are the justices showing that they're concerned about? What are, for example, 20 years ago, the court's very different, as everyone knows, from the court today. You are far more likely to get the attention of this court if you are bringing up an issue of statutory construction. We have strict constructionists on the court. So if you say, or regulatory issues, you say, my issue is that a regulator has exceeded the scope of their authority under the statute that enabled that, regulatory body to act. That's something, obviously, given what happened with Chevron in the last term, that is very likely to get their attention if it's framed the right way. You can say all of that, but if ultimately the underlying case doesn't actually tee up that issue, then they may not take it up. But it's more than just format. It's more than just being on time. It's really understanding sort of, what is it about my case? What is it about what happened in my case that is so egregious, but also fits within the current mandate of the court about the types of things that they are looking at? For example, someone who's, gone through an administrative trial and feels like that agency doesn't have the authority to conduct that administrative trial. We now know that's a key issue for the court. So we saw that with the SEC. Maybe we're going to see that now with the EEOC, or we're going to see that with the Department of Labor. And so people are knowing that those issues are out there, and those are the kind of issues that'll get their attention, but they have to be framed the right way in the brief.
So switching gears a little bit, you've written your cert petition, and so then what happens? What comes next, and what should folks expect in terms of the Supreme Court's process?
Yeah, typically, again, as I mentioned earlier, there'll be an opposition to that, but there also can be, what are called amicus briefs. We recently filed one in a case that didn't involve our client in the case, but we represent a trade organization that was very interested in the issue. So we filed basically an amicus brief, which means friend of the court brief, on one side or the other. So in a lot of, for example, labor and employment cases, or in certain business cases, we'll see filings by the Chamber of Commerce, or we'll see filings by the Association of State Attorney Generals, or we'll see, and those, so they're not parties to the case, but they want to weigh in one way or the other. And typically an amicus brief, a successful amicus brief in the cert process is doing exactly what we just said, which is it's supporting why this is an issue the court should take up. If you're supporting the petition, if you're against the petition, it's saying there's nothing to see here. This is not an issue that needs to be addressed. It's perfectly clear in the cases that this is not a federal issue. There's no conflict. There's not a constitutional issue. You don't need to look at this court. And so those briefs come in, and those have to be filed within 30 days. So, it's a pretty quick turnaround. That was certainly the case on the one we just filed. And you tend to need to identify, who you are, why you have an interest in the case, and keep your arguments to that interest. That's the key thing. It's like, we are this trade organization. We have this very specific interest. Here are our members. Here's who we represent. This is why this is important to them. But it's not like the fulsome briefing of what you'd see, but that the parties themselves will submit. It's much more focused on, here's who we are, here's why we think this is important, and here's why we think you should address this at that stage. Obviously, on the merits, then maybe it's a little more expansive as to why we believe you ought to rule one way or the other.
And I think the Supreme Court's rules, correct me if I'm wrong, actually discourage amici from essentially just, duplicating the arguments that have already been made by the parties, because the court doesn't view that as helpful to them. They view it as just additional paper that that is added to their slush pile.
Correct. Yeah, that's very much the case. What they want to hear is sort of, again, help us out on the edges as to why this is important, why this may have a broader application and a broader implication than just resolving a dispute between these two parties. Because if all I'm doing is resolving a dispute between these two parties, the lower courts are fine handling that. But why is this important? Why does this rise to the level where we need to weigh in? And what are those broader policy implications that might come out of leaving the case alone versus taking it up and making this decision?
So amicus briefs and the cert petition and opposition have all been filed. The papers are circulated, and the justices decide to take up the case. That sort of brings us to the next stage of the life cycle of a SCOTUS appeal, which is the merits briefing. So how is it similar, the merits briefing in the Supreme Court, to your appellate briefing in state appellate courts or federal intermediate, the federal courts of appeal, and how is it different?
Sure. So it's similar in the sense that you need to tell the court what the case is about. So in any brief, you're going to have to explain, what are the facts? What's the record below? What are the procedures? What happened? So how do we get here? And you have to define for the court sort of, those lower court proceedings, what the issues were decided, by the district court, by the appellate court, and then sort of how do we get here? But the difference, so all of that's going to be very similar, in terms of, just orienting the court to what are we here to decide. The difference is in the appellate court, you might have 4 or 5 or 6 different grounds for appeal.
Right.
That a jury instruction was incorrect, or this application law, or this piece of evidence should have been stricken. None of that is going to be relevant in the Supreme Court. In the Supreme Court, whatever you said to the court in your cert petition as to why they should take it up, that's what you should be briefing. So while you'll still talk about the facts and the law and the proceedings below, the vast majority of what you might have argued in the appellate court is not going to be re-argued in the Supreme Court. What's going to be argued in the Supreme Court is the very specific issue that you argued previously is why this is important and why this is in front of the court. And so that's a really critical aspect of sort of thinking about, from day one, kind of what is this case really about from a Supreme Court perspective versus from a district court or an appellate court perspective.
It sounds like one objective of the merits briefing is also to reassure the court that they didn't make a mistake in taking up the case, given that they take so few appeals. Is that something that can happen? Can the Supreme Court essentially say, whoops, we shouldn't have taken this case. We're gonna undo our grant of certiorari.
Well, they could summarily decide it.
Yeah.
There are certain procedural tools they have in the toolbox. It's pretty rare, however, that they would, take a case on cert and then determine subsequently that the issue that they took it up on, they might criticize the parties for not having really addressed the issue. And that can come out at oral argument, which is a pretty rough place to have it come out. As a lot of people know, and a lot of practitioners know, a lot of the oral argument process is about the judges essentially talking to each other and using sort of their views to kind of, try to influence the other justices. But if all of the focus is on the attorneys look, you filed a petition for cert saying this was the issue and we don't have any briefing on this, I think that could be a very uncomfortable day in court.
Speaking of the oral argument, perhaps no task is more daunting for most litigators than the prospect of preparing and presenting an oral argument in front of the U.S. Supreme Court. In your experience, what make for the most successful oral arguments, and how should one think about the process of preparing for that presentation?
Yeah, I think the biggest part is, quite frankly, listening. Obviously, you're going to have your prepared remarks, but typically, if it's an active court, and this court's been pretty active, you're not going to get very far before you're going to start getting questions, and you're going to be able to size up, what each justice is thinking in terms of, how they're approaching, the different issues that are in the appeal. What I think is a really valuable exercise, if you haven't done it, is to go listen to the arguments on the Trump immunity appeal to the Supreme Court, where each justice, in that case, I think every single justice had questions. I don't think any justice stayed quiet. Justice Thomas has historically had lots of arguments where he has not asked a single question. But I believe in that argument, every judge asked questions, and you got a real sense of sort of how the back and forth, essentially it's they have things on their mind that they feel are the critical issues that they need to address, not just with themselves, but with their other justices. And so, where I think, practitioners can go a little astray is if they aren't really listening to the question and they don't answer the question and they keep going back to their script, and they don't directly address what the judges are asking them, the justices are asking them. That always, you can see the discomfort in the courtroom and hear it when you listen to the arguments when that happens. Part of what they're trying to do is two things. One, get actual answers to their questions about, what your position is. But then secondarily, like I say, they're trying to sort of express a view that the other justices will hear in the hopes that, they can, if not influence them, get a sense of sort of where the fight's going to be over how the decision's ultimately going to come out.
And how should one think about the issue of concessions, right? Picking up on the immunity case, right? One of the sort of more widely observed exchanges in that oral argument were between Justice Barrett and the counsel for Mr. Trump, I believe, in which she seemed to get a number of really sort of important concessions from counsel in terms of what conduct was sort of personal and not official in that particular criminal case. How does a practitioner think about, sort of responsibly handling questions that are designed to extract concessions?
Yeah, you have to be honest, right? You can't lie. But not all questions have a yes or no answer. I think Barrett did a very, good job of being very, very specific, much like a cross-examination where there were very specific questions that really warranted a yes or no answer. But that's unusual. Usually the question will be more broad, and so it can be a no, but you know, if you know the question is directly against your client's interests and your arguments in your brief, you can disagree and say, no, that's not, because there may be enough in the question that you can disagree with the question without it being just untruthful, but then explain. So it's no, but the way you ask that question doesn't really address the issue, or no, but you know, this. And again, sort of reframe the issue in the way that you want it framed, while sort of politely disagreeing with the premise that's in the question. But if a direct question is asked, as it was in that argument, and the answer is factually what it is, then yeah, that's a concession you're going to have to make, because you're going to lose all your credibility if you answer a question that everyone in the room knows what the answer is and you say something different, which I think was what was happening in that argument.
And so in terms of, you know, the big picture from start to finish, in your experience, how long does a Supreme Court appeal take to play out from, you know, its inception to the disposition of the case, or are there sort of wide variations?
Well, there could be variations depending on where in the case it lands, but in the typical case where you're filing a petition after judgment, you obviously have the 90 days, and then you'll probably get a decision on your cert petition within, you know, another, you know, 60 to 90 days after you file it. So now we're at, you know, 18 months, or I'm sorry, 6 months. If the case is taken up between briefing and argument, you're probably looking at another, you know, 9 to 11 months ish. So, you know, all in, you're talking about a year, maybe a year and a few months, you know, from whatever judgment you're appealing through a decision. But again, in many, many cases, the vast majority of cases, the cert petition is going to be denied. And so, you know, that'll obviously happen much sooner. But if you in fact have a case that goes up and through the whole process, yeah, you're looking at, I think the last one we handled here was, I think I want to say about 16 months, start to finish.
So in other words, don't hold your breath.
Yeah, nothing's going to move quickly, but it all feels like it's moving extremely quickly.
Right.
Because everything is sort of due, and you have, you know, a lot of paper moving around, particularly if you have amicus briefs being filed, if you have, you know, broader issues that are being addressed. It does always seem, even though that seems like a long time, that there's always something to be done in this process. And it's a very unique practice, and it's you know, obviously the issues are very serious. So, you know, a lot of time and energy and effort goes into every aspect of the process as it goes up through the process.
That makes sense, and all the more reason to bring to bear the expertise of appellate counsel who have been around the block and are intimately familiar with the both federal appellate practice and practice at the Supreme Court. So I think sadly we're pretty much out of time, Chris, which is too bad, because I think we could probably talk about this all afternoon.
No, we could. We both like it so much, but no, this has been great, and hopefully people found it informative and interesting. And you know, obviously, you know, every case is different, but there are certain sort of baselines that folks can think about, so they make sure they capture the right issues, and they don't, you know, they aren't intimidated by the process.
Absolutely. So I want to just thank everybody who's out there, you know, tuning in for joining us. This was episode 3 of Decoding Appeals, and we'll look forward to seeing you in the next episode.
Thanks, everybody.